board report to capture the related party arrangements. This was not required as per the old act. And it will also capture the justification of the undertaking such related party transactions. And Section 186 disclosure around loans, investments and now through the financial statement. Earlier it was through the register, now we have to give it in the financial statements. This is the most, I would say, controversial amendment to the Act, and which has created already a lot of heartburns. And at this I will go slightly in detail how the government also is reacting to this particular UN cry which is coming up. So what is the change here? The erstwhile section 295, which was applicable only to public companies. The new version 185, which is applicable to private companies and is already mandatory from 12th of September 2013. So what does the section say? Any loan to any director or any of his related party, cannot be given. The earlier 295 exempted private companies. So now there is no exemption, private companies covered. The earlier 295 exempted loans from holding to subsidiaries. Now there is no exemption. Of course, there is a circular. I'll discuss the circular, but in the section there is no exemption. And when I read the circular, how they are, language and how they are doing it, you will be very amused. Under the existing Act, prohibited loans guarantees could have been made with the approval of central government. Now, no provision for central government approval. As I mentioned, those 15 sections I want to see, because in this coverage, everywhere where earlier central government approval has been removed. Just to in case of difficulties, you can't even go to central government. What are the exceptions which are given in 185? Loan given to managing director, whole-time director in the normal course of employment is exempt. Loans, etc., given in the ordinary course of business is exempt. Now, this would be applicable to NBFCs. When I say NBFC, only lending NBFCs, not assuming you are an investment company predominantly, which is or a share trading company, then this may not apply, because your ordinary course of business is not to give loans. So only to lending companies, your NBFC which is into the lending activity, only those will be exempt. And what are the consequences for non-compliance? Fine to the company from 5 lakhs to 25 lakh, and to the director 5 lakh to 25 lakh, or imprisonment up to 6 months, or both. In the earlier section 295, the imprisonment, there was an exemption in case the loan was repaid in full. Under the current section 185, even if you have repaid the loan, the penal consequences still remain. Although I hope they administer it, in a slightly better manner. Section 185, person in whom director is interested, just to inform, is a director of a lending company or holding company, partner or relative of any such director, any firm in which such any director or relative is a partner, any private company of which such director is a director or member. These are more or less like the old thing, old definition. What is changed is the next one. Any body corporate of which 25% or more of the total voting power is exercised, controlled by any such directors. Now here again that word control is, you have seen the definition of the word control. It is directly or indirectly, and control could be by way of your agreement, by way of your shareholders agreement, any other agreement, voting rights. So this is a very, very wide coverage. And any body corporate, the board of directors or managing director is accustomed to act in accordance with directions and instructions of the board of directors of any other director of lending company. So the fifth bullet is the critical one, control. 25% of the body corporate. Here, a lot of people could get covered. Again, bigger owners for all the compliance people, company secretaries, chartered accountants who are certifying in some manner need to be careful. I'll read out the circular verbatim, possibly, that will give you some how the government is thinking on this. Yeah, there is a date, a typo error, it is 2013. And I'll just read out the first circular. It's hardly 2 paragraphs. This, it says to all ROCs and all regional directors, subject clarification with regard to applicability of provision of section 372A of the Companies Act 1956. Sir, The ministry has received number of representations consequent upon notifying section 185 of the Companies Act 2013 with loans to directors, which is corresponding to section 295 of the Companies Act 1956. Full stop. Next line. Section 186 of the Companies Act is yet to be notified. It is clarified that section 372 of the Companies Act dealing with intercorporate loans continue to remain in force till section 186 of the Companies Act 2013 is notified. This issues with the approval of the competent authority, so and so signed. Here the question is, look at the first para. The issues are pertaining to 185. Then they are saying section 186 is yet to be notified, and hence, to the extent of intercorporate loans, how ambiguous is it giving any comfort? It is not giving any comfort. Assuming somebody has given loan, will this help? In my view, no. To any of those directors related party. Look at the next circular which has come. Now, let me tell you, most of the banks and the financial institutions have created a hue and cry with the Ministry of Finance that they are not able to get guarantees from, whether it is holding subsidiary or group companies, as a private companies in the group. They are not able to get guarantees because it's a good excuse for the promoters that under this section we cannot give you. We are barred to giving you. So who is the sufferer? Again, banking sector. In turn, in case there are going to be NPAs, you are not going to be able to recover from the guarantors because now the guarantee is no longer valid. Who is going to be suffered? It is the common, people. In the sense, it is going to be the government is going to bail out. As it is, you have seen such huge NPAs what is happening, and this is going to increase that particular thing. And see the next circular, which is 14th February 2014. To all, again, regional directors, all registrar of companies, all stakeholders, subject clarification with regard to section 185 of the Companies Act 2013. That was November 13, now this is February 14, after almost 3 months. Sir, this ministry has received number of representations on the applicability of section 185 of the Companies Act 2013 with reference to loans made, guarantee given, or security provided under section 372 of the Companies Act. Again, why they are tying about 372, I don't know. Okay. The issue has been examined with reference to applicability of section 372A of the Companies Act 1950 vis-a-vis section 185 of the Companies Act. Full stop. Section 372 of the Companies Act 56 specifically exempts any loans made, any guarantees given or security provided or any investment made by a holding company to its wholly owned subsidiary. Whereas section 185 of the Companies Act prohibits guarantee given or any security provided by a holding company in respect of any loan taken by its subsidiary company except in the ordinary course of business. In order to maintain harmony with regard to applicability of section 372A of the Companies Act 1956, till the same is repealed and section 185 of the Companies Act 2013 is notified, it is hereby clarified that any guarantee given or security provided by a holding company in respect of loans made by a bank or a financial institution to its subsidiary company, exemption as provided in clause D of subsection 8 of section 372 of the Companies Act shall be applicable till section 186 of the Companies Act 2013 is notified. This clarification will, however, be applicable to cases where loans obtained are exclusively utilized by the subsidiary for its principal business activity. Now, issue is it only holding the subsidiary? So, only part of the issue. Issue is see how, I don't know whether you call it hypocritical or just to, how can you put in 372 and because of that you hold? You should come out directly saying that we hold this section 185 from implementation till the time we notify the whole act or whatever. What happens to private company, I would say group companies. Forget holding, it's not a holding subsidiary. A guarantor given by one group company to another group company. Given by a director to somebody else. So it is, this again shows the mindset. They want to, as if they want to come out with this thing in a very miserly manner. Okay, give small exemption. And despite, the representation is in November, made in February also, huge, humongous representation being made. But this is the way the government is functioning, and I think this will be a huge, problem as far as companies are concerned. Most of our clients would have given loans after 12th September 2013 without, knowing the repercussions of this particular act, and which is going to be, problematic. And I only wish that they obey the applicability of section 185 completely, not in this piecemeal manner. They're only holding subsidiary, only for guarantees given. What about the loans?
What about earlier loans given?
Earlier notes will remain. There is no provision right now for repayment. There, I think anything given before 12th September, I don't think there's any problem. Don't repay it, let it remain as it.
If the terms are changed.
What about bookdates?
If renewals happen, then it's a new loan. See, by and large, luckily what happens, most of them are not called, I'm saying in a typical private sector, a private company scenario, there are no specific terms, conditions, etc. Generally. So don't repay it. If you repay it, then you cannot give fresh loans.
What about bookdates?
Book dates, the same thing will apply. The erstwhile 296. If in the nature of loan, it will be a loan. I am not discussing 222 because that anyway we know. How do we say that? Depends on the facts of the case. You read the wording. See, again, I'm saying miserly. See, if you have to give, there should be slightly liberal, large-hearted. Just do everything. I'll be away 185 till the time. You look at the whole thing. And despite getting so many representation, and who's going to be impacted in the banking sector? Anyway, I'll come to you. The be applicable to cases where loans are exclusively utilized as subsidized principal business activity means. See, again, let me tell you, my gut feel is this is arising out of the Ketan Parekh scam. There, certain listed companies gave loans to various levels of the subsidiaries, etc., and the money was routed to the capital market. Possibly to plug this has come in. So maybe the private company or the subsidiary company's principal business will be something else, but it has gone to the capital market. To plug that, this has come in. So principal business is what is the main activity? Assuming it's manufacturing, it has to be for manufacturing. It cannot go to capital market. If it is manufacturing, it cannot go for gold trading. So like that it will be depending on the facts of the case. You cannot generalize that. I think somebody had a...
Don't given by private companies, public companies, getting common director, will it be exempt from political?
No. If it covers in that 25% thing,
It's not covered, directors are not holding more than 25%.
then it will not be covered. That will not be covered. So unless it is getting covered in this particular definition, so only controlled, and you look at not 25%, you look at control. Not direct 25%. Ultimately you are having more than 25% through a chain. Then you have to look at the chain also. And control is any other agreement, any other, if you are controlling through that also it will be covered. So it's not only 25%, it's only one of the trigger.
Sir, even today the loan given to by holding company to its wholly owned subsidiary is exempted, but not by holding company to its subsidiary company by virtue of the circular.
I agree with you. That's why you see the drafting. It is drafted with wholly owned and then they are saying subsidiary. That's what I'm saying. They should be large-hearted. Why only holding subsidiary? Okay, it is not wholly owned, it is say 90%, it is 80%, whatever. That is only one part of it. I'm saying larger private company to private company, why couldn't they have said, okay, we hold till the time we look at the report, and again, not to benefit the corporate, that is to benefit the public sector. If at all this issue is there, it's going to impact banks. When they are coming out with this thing, the representation has gone from Indian Bank Association to the Ministry of Finance very, very strongly, and this is a repercussion. But they want to release only little by little. And that also they are goofing up. As you rightly said, wholly owned subsidiary, when it comes to the conclusion, they say subsidiary. I'll read out, earlier the first para says wholly owned, second para says subsidiary. So it could be any subsidiary. So that's the either lack of application, hypocrisy, I don't know what words to use. It could be anything. You can judge your own manner.
Why to go into all this circular and all? Please, section 185 says starting that unless specified elsewhere in the act.
Absolutely.
Now, unless specified elsewhere in the act takes it to 372A.
No.
Because 186 till the time 186 is not announced. The 196, the 372A is not repealed. And if 372A is not repealed, it is very well of the company. See,
there is a legal issue here. Question is this connected, not connected? Lot of law firms recently after this next circular are giving, not exactly, in their opinion, they say this is valid and you can do whatever you want. Even, you can give any loans, etc. My view, you will be trading on very, very weak wicket. My individual view is, my opinion is, those two sections are, they are not connected in any way. However the government may want to try it, if it is tested in the courts of law, and if you want, I can just read out. What is the concept? Those are 186 pertains to your amount which you can invest or you can give loan. 60% of net worth, 100% of free reserve, whatever.
But why to look at 186? 186 is not this thing operation.
But 185 is there, na? So now 185 is operation.
185 start with that unless specified elsewhere in the act.
So right now there is right now there is no other specification in any other act.
But till the time the corresponding section is.
There is no corresponding. Question is, where is any connection to the section? Today, after this section comes into being, 185, any loan, what is that 186 going to have a bearing on this, or 372 is going to have a bearing on this?
Till the time 186 is notified, 372 is very well in place.
In my view, there are two separate things. One is you cannot give loans to direct or related parties. 372A and 186 applies to the quantum which you can invest. Quantum is 60% or 100%. 60% on net worth, 100% of free reserve is what you can invest. What is the connection between the two? Listen, this says you cannot give, unless if you want, you can read out 185 or anything. In my view, there is no connection. Of course, that what you are saying is a view, good that you pointed out. That view is being taken by many law firms. They're giving opinions, and of course, let me share. If somebody has done a transaction, this opinion could be taken just to save that particular company just by way of some measure. But please do not, or you may read it. We can have a difference of view. My view is there is got no connection.
My second question is this February circular exempts only guarantee given to banks. So we can't give a guarantee to vendors.
Absolutely, I agree with you.
So what in case that there is a company which is funding its subsidiaries for its day-to-day business because the subsidiaries are not working, then what can be the other way out for
You capitalize those companies now. You issue share capital or whatever. That is in your hand. Instead of giving loans.
So but the same thing then
60% or 100%. That will apply. That will apply. See, if you looked at the way almost all the privileges of private company has gone, you remember my first comment which I gave. This is going to be anti-growth of corporate service in our developing country. Do you want to increase the corporate growth or to restrict it? In my view, all these provisions are going to be completely, obstructing the growth of the corporate sector in India. And not only that, today we have got something like 13 lakh companies, out of which around 8-9 lakhs are active, balance are dormant. There will be a shrinkage of those 13 lakhs. Even the government itself will get less revenues. Because who is going to face this cost of compliance? Already in Calcutta, all the people have started now consolidating. Calcutta is famous for companies. They are already looking at how to, even large industrial groups I know have started looking at how to start consolidating and merge and there are other repercussions also. I'll come to some other matters which are there. I think yesterday Himanshu must have pointed out on the definition of subsidiary and all. Even if you own preference capital, it could be a subsidiary. Today we use preference capital freely for the purpose of structuring. Instead of loan, I give preference capital. Now, by only virtue of owning the preference share, if some other company could become a subsidiary, you can understand, and consolidation being mandatory, it's going to throw completely, wayward, I would say, results and repercussions. And look at the comment of the ministry, the suggestion. See, this suggestion was made during the time this was being discussed. And I'll just read out the relevant. Generally, the director should not be encouraged to avail of the loans or guarantees from companies. They should be allowed remuneration of city fees only. In case company decides so, loans to directors should be allowed only when company has specifically approved such loans. Disclosure to be made to shareholders through the explanation statement, etc. This is all fine. Anything else? This is the most critical. I'm good that you pointed out that's the legal view which has been taken, but my view is different. I think those two don't have any connection. There's the only thing to save some action which has already taken between 12 September till date. You could use that opinion and take some legal opinion, keep it on record. Then we go into 186 which we were discussing. Earlier 372A was applicable only to public companies. Now 186 is applicable to all companies including private companies. Earlier exemption given in case of loan from holding company to wholly owned subsidiary has been withdrawn. Even those will be covered in the 60% and 100%. Under the existing act, no loan could be given at a rate of interest lower than prevailing bank rate. And now it says you cannot give any loan which should be at a rate of interest lower than the prevailing yield of 1 year, 3 year, 5 year or 10 year GSEC closest to the tenure of the loan. So you get a 3-year loan, it has to be matching with the 3-year, it cannot be lesser than the 3-year GSEC rate. So you have to keep track of the GSEC rate of the date of the transaction whenever you are giving the loan, or 5-year or whatever the GSEC rates are. Have some proof so that tomorrow, because after 5 years, if somebody is going to question you, you'll need that proof. What was the GSEC rate? Additional disclosure in the financial statements. Now read, this is also interesting. Full particulars of the loans given, investment made or guarantee given or security provided. And read this. And the purpose for which the loan or guarantee or security is proposed to be utilized by the recipient of the loan or guarantee of the security. So in your financial statement, you have to give the purpose for which it is going to be utilized. Section 186 restricts the layer of investment subsidiaries to two. You can have only now two levels of investment subsidiaries. Earlier you could have had as many investment subsidiaries. Only exemption which has been given is, in case you're incorporating a company abroad, and in the local registration you can have those type of subsidiaries. You can have more than two. And in India also you can have more than two if by some statute you require to have that investment subsidiary. For example, recently number of people have gone for the banking licenses. Now that banking license, the company which will be doing the banking transaction has to be held by a NOFHC. This is a financial holding company. Or if you want to form an insurance company, possibly a separate holding company may be required under the Insurance Act. So those things which are required under the Act, you can have a separate investment subsidiary, but not otherwise. And what are the provisions? Again, just for the sake of our understanding, which is no change. No company shall directly or indirectly give any loan or any to any person or other body corporate, give any guarantee or provide security in connection with the loan to any body corporate or person, and acquire by way of subscription, purchase or otherwise the securities of any other body corporate exceeding 60% of its paid up capital, free reserves and securities premium account, or 100% of free reserves and securities premium, whichever is more. If the limits are exceeded, then prior approval of special resolution in general meeting shall be necessary. Now this again, you have to disclose the specific name of the company, etc., etc. It was not, you cannot have an omnibus resolution. Earlier we used to have an omnibus resolution. So like the public companies, you have a specific resolution. I want to invest in so and so company. So that freedom is now minimized. I mentioned this fleetingly earlier. The definition of subsidiary company has changed, which says exercise or controls more than 1/2 of the total share capital. Earlier it said 1/2 of the total voting power. So now it says share capital. So what does it mean? As I mentioned earlier, say a company A, 5 crore capital is owned by company B, equity capital, and 20 crore preference capital is owned by company C. Under the 1956 Act, this company A was a subsidiary of company B because by virtue of the equity holding, of 100% of the equity holding. Under the new Act, this will become a subsidiary of company C, which holds the preference shares. Now, these type of preference shares structuring was very common across various groups. Again, instead of loan, we wanted to show preference capital, so it increase your net worth, etc., etc. So all that will. So what will happen is subsidiary of B will now become subsidiary of C. So and now consolidation is mandatory, even for private companies. So it will have to be consolidated company C. Actually, say company C is only a financial investor through preference shares. It has got no other stake. It will have to start consolidating the company, have full information. So it will give rise to peculiar, repercussions. Subsidiaries shall also include associate and joint venture. And section 287, see, we had in 186 that the company will not have more than 2 layers of investment subsidiaries. They have given an additional provision in section 287 which defines subsidiary, that it shall not have layers of subsidiaries beyond such number as is prescribed. Right now they are not prescribed the. So apart from investment subsidiaries, even normal subsidiaries, say textile manufacturing company wants to start manufacturing chemicals and wants to have a separate company. So they might prescribe that you cannot have more than say 5 underlying subsidiaries or whatever. So right now it is silent. Associate company means a company in which other company has significant influence and is not a subsidiary of other company and includes a joint venture. Significant influence means control of at least 20% of total share capital or of business decision under an agreement. Now this is a definition of associate. Now what does our AS accounting standard definition says? There is a rebuttable presumption. If you rebut that even despite owning 20% or more, the company is not an associate, you can still say it is not. But that rebuttable presumption is not there in the company. Is that the moment you have a trigger of 20%, it will become an associate. So you have to consolidate that. and it is defined to include a joint venture also. Both terms also refer to total share capital. Here again, the same preference share capital somebody owns, even then it will be an associate. Like we decided on the subsidiary, it is not equity, it is total share capital. So somebody owns 20% of the total share capital, which includes preference, even then it will be an associate. So this also is going to create problems. The consolidation of financial statements shall be made in accordance with the account. This is a saving grace which is there in draft rule 9.4. The problem is they say associate include JV. Now how do I do the JV consolidation? Should it be by way of proportionate consolidation or equity method and associate as it is there? So of course luckily they say it should be so as per the accounting standards, so possibly the JV consolidation will happen as JV. Restriction on acceptance of deposits. They have classified, again like the earlier times, banks and NBFC, the rules will be prescribed by RBI, manufacturing tradings and all other companies will be by chapter 5 and rules by central government in consultation with RBI. The current sections are 73 to 76. As I mentioned, private companies can accept this is for draft rules, is subject to change. The draft rules can kindly be warned. What I am saying is that for the draft rules, so which presently says that in case of private companies, any amount from shareholder or directors will not amount to deposit, provided declaration that amount is not being given from borrowed. Exactly what is there right now. In case of public companies, what is the public companies other than eligible companies? They can only borrow from the members. They cannot borrow from public. And they have to issue a circular. We'll discuss what the circular is, and they have to issue an advertisement. Even if they are borrowing from the members, they have to give an advertisement in the newspapers, which circulating in the state, one English and one vernacular, and that quantum will not exceed 25% of the paid up share capital and free reserves. This is for companies, other than the eligible companies. Which are the eligible companies? Eligible companies can accept deposit from public companies, and the criteria is the net worth has to be more than 100 crore, turnover has to be more than 500 crore, and there has to be, the company has to take consent in the general meeting by special resolution and file it with the registrar of companies RBI as the case may be. And what are the conditions? The condition that deposit from members should not exceed 10% of the paid up capital and free reserves. Other deposits should not exceed 25% as is currently there. But now you just juxtapose there with the earlier section. Companies which are below 100 crore capital and 500 crore turnover can accept 25% from members. And eligible companies can take 10% from members and 25% from public. So that's the again, issue advertisement in newspapers. You have to upload your copy of the circular on the website. Then you have to comply with the section 73.2, that is circular and rules framed by central government. You have to have a credit rating of at least adequate safety and renew it every year. And in case of secured deposits, you have to create a charge within 30 days of accepting the deposit. And government companies can accept up to 35% of their net worth as deposits. Sorry, yeah.
This credit rating, a lot of people invest based on this credit rating. So are credit rating companies being taken to task like that?
Today only the chartered accountants and auditors are taken to task. For example, what is happening